Case number 1. Gary Gilmore. On January 17, 1977, at the Utah State Prison in Draper, a firing squad prepared to carry out the first execution in the United States in nearly a decade. The condemned man had fought for this moment. He had fired his own lawyers, battled the ACLU, defied his mother, and demanded that the state kill him. When the warden asked if he had any final words, Gary Mark Gilmore spoke 4 syllables that would eventually become one of the most famous advertising slogans in history. "Let's do it," he said. Moments later, 5 rifles fired. The 10-year moratorium on capital punishment in America ended with a man who had actively fought for his own execution. Gary Mark Gilmore was born Faye Robert Kaufman on December 4, 1940, in McCamey, Texas. His name was changed shortly after birth. He was raised in an unstable, abusive household dominated by an alcoholic con-man father who beat him and his siblings regularly. Gilmore was a high school dropout who left school in the 9th grade, though he later earned a GED in prison and possessed a high IQ. He was never married, but carried on a toxic, obsessive relationship with a 19-year-old woman named Nicole Baker. By the time he was 35 years old, Gilmore had spent more than half his life incarcerated. He had been sent to reform school at 14 and cycled through various prisons for armed robbery, assault, and auto theft. He was diagnosed with antisocial personality disorder and evaluated for psychopathy. By 1976, he was destitute, living on his uncle's couch in Utah, and known by local police and his own family as a dangerous, institutionalized criminal incapable of adapting to civilian life. The 2 men Gilmore murdered were Max Jensen and Benny Bushnell. Jensen was 24 years old, a gas station attendant working his way through law school. Bushnell was 26, a motel manager and a new father. Both were married, both were respected members of their local Mormon communities, and both were working late-night shifts to provide for their families. They were complete strangers to Gilmore. Their vulnerability was their isolation. They worked alone at night in businesses with accessible cash registers and no protection. On the night of July 19, 1976, at approximately 10:30 p.m., Gilmore walked into a Sinclair gas station in Orem, Utah, and ordered Jensen to lie down on the bathroom floor. Jensen complied. Gilmore shot him twice in the head, execution style, with a .22 caliber Browning automatic pistol. He stole the cash from the register and left. Gilmore had purchased the gun shortly after being released on parole and had stalked businesses before choosing his target. The next night, at approximately 10:00 p.m., Gilmore entered the City Center Motel in Provo, Utah, and shot Bushnell in the head. He stole cash and fled. While attempting to dispose of the weapon, Gilmore accidentally shot himself in the hand. He tried to hide the gun in a bush near the motel. The motive was ostensibly robbery, but those who knew him understood that the murders were driven by severe anger, nihilism, and displaced rage over his failing relationship with Nicole Baker. The investigation moved with shocking speed. A motel guest discovered Bushnell's body and called police. Jensen was found within an hour. Investigators recovered the .22 caliber handgun hidden in the bushes and followed a blood trail leading away from the motel. The blood matched Gilmore's type. He had left his own trail when he wounded himself. Ballistics testing matched the gun to the bullets recovered from both victims. A mechanic named Peter Arroyo came forward and told police he had seen Gilmore hiding the weapon. Gilmore's parole officers had known he was spiraling out of control and drinking heavily, but they had not revoked his parole. The breakthrough came when Gilmore, desperate for medical help with his hand wound, called his cousin Brenda. Realizing what he had done, she turned him in. Detective Jerry Chittister of the Provo Police Department arrested Gilmore at his cousin's home on July 20th, 1976, less than 48 hours after the first murder. Gilmore did not resist. The trial began on October 5, 1976, in the 4th District Court of Utah County. Judge Robert Bullock presided. The proceedings lasted only 2 days. Gilmore was represented by court-appointed attorneys Craig Snyder and Michael Esplin. Prosecutor Noel Wooten presented overwhelming physical evidence: the ballistics match, Gilmore's bleeding hand, and eyewitness testimony from Peter Arroyo and Brenda. The defense attempted a lack of intent and insanity defense, but Gilmore himself sabotaged the effort by refusing to cooperate. He did not testify. The jury deliberated for less than 90 minutes and returned a guilty verdict on 2 counts of first-degree murder on October 7, 1976. Gilmore remained stoic and indifferent throughout. Judge Bullock sentenced Gilmore to death immediately following the verdict. Under Utah law, Gilmore was given a choice between hanging and the firing squad. He chose the firing squad. When asked if he had anything to say, Gilmore stated that he welcomed the sentence and had no desire to rot in a cell. His mother was horrified and later attempted to intervene legally. The families of Jensen and Bushnell expressed quiet relief. What happened next was unprecedented. Gilmore fired his lawyers and fought the ACLU, his own mother, and the NLEACPAIP to stop them from filing appeals on his behalf. He wanted to be executed. The United States Supreme Court temporarily stayed the execution, but Gilmore's legal team successfully argued that a competent inmate had the right to waive his appeals and choose death. The courts upheld that right. Only 3 months passed between conviction and execution. While on death row, Gilmore attempted suicide twice because, in his view, the state was not killing him fast enough. Gary Gilmore died by firing squad on January 17, 1977, at the Utah State Prison in Draper, Utah. He was 36 years old. His execution ended the 10-year de facto moratorium on capital punishment in the United States that had been in place since 1967, following the Supreme Court's decision in Furman v. Georgia. Gilmore's case became a national media sensation and was immortalized in Norman Mailer's book, The Executioner's Song, which won the Pulitzer Prize. His final words, "Let's do it," were later adapted by advertising executive Dan Whedon, who admitted that the phrase inspired Nike's iconic "Just Do It" slogan. Gilmore donated his corneas to science immediately after his death. The case established the legal precedent that a competent death row inmate can volunteer for execution by waiving all appeals. Max Jensen and Benny Bushnell, 2 young men murdered for pocket change while working late shifts to support their families, were largely eclipsed by the media circus surrounding their killer. Gilmore fought civil rights organizations to secure his own death. Jensen and Bushnell had no say in theirs. Case number 2, Aileen Wuornos. The jury in Volusia County Circuit Court delivered its verdict on January 27, 1992. Guilty of first-degree murder in the shooting death of Richard Mallory, a 51-year-old electronics store owner whose body had been found in the woods along Florida's I-75 corridor. Aileen Wuornos erupted as the verdict was read. She screamed obscenities at the jurors, shouting, "I'm innocent! I was raped! I hope you get raped! Scumbags of America!" It was the first of 7 murder convictions that would follow. By the time the legal proceedings concluded, Wuornos had been sentenced to death for killing 7 men over the course of nearly a year. The case would inspire books, documentaries, and an Oscar-winning film. Wuornos would be widely, though inaccurately, labeled as America's first female serial killer. Aileen Carol Wuornos was born Aileen Carol Pittman on February 29, 1956, in Rochester, Michigan. Her mother abandoned her. Her father, who had been incarcerated for child abuse, later hanged himself. She was raised by a violently abusive grandfather. She dropped out of school in early adolescence and gave birth to a son at the age of 14. The child was placed for adoption. She was briefly married at 20 to an elderly man, but the marriage ended quickly. By the time she was in her 30s, she was living as a street-level sex worker and drifter, surviving in motels and stolen cars. She had a long-term romantic relationship with a woman named Tyria Moore. Wuornos had an extensive criminal record spanning multiple states: assault, armed robbery, check forgery, and prostitution. She was diagnosed with borderline personality disorder and antisocial personality disorder, and she exhibited severe paranoia. She lived in extreme poverty and operated under multiple aliases, including Lee Blahovec, Lori Grody, and Cammie Marsh Green. Between December 1989 and November 1990, 7 men disappeared along the I-75 corridor in Central Florida. Their names were Richard Mallory, 51, David Spears, 43, Charles Carskadden, 40, Peter Seams, 65, Troy Burris, 50, Charles Humphreys, 56, and Walter Antonio, 62. They were a mix of blue-collar and white-collar workers. Mallory owned an electronics store. Burris was a sausage delivery man. All of them were unknown to Aileen Wuornos. All of them were men seeking sex in isolated rural areas. Their bodies were found in Marion, Volusia, Citrus, and Pasco counties, dragged deep into the brush and left to decompose. Their families later spoke out against the media's romanticization of Wuornos, insisting that the men they lost deserved to be remembered with dignity. The pattern was consistent across all 7 murders. Wuornos would hitchhike along the highway and offer sex for money. She would direct the men to secluded wooded areas. Once there, she would produce a .22 caliber revolver and shoot them multiple times at close range. She would steal their cash, cars, and belongings, then drag their bodies into the brush. She wiped down the stolen vehicles with rags to remove fingerprints and abandoned them later. She fenced stolen items at pawn shops, leaving a trail of receipts. The prosecution argued that the motive was robbery. Wuornos claimed it was self-defense, insisting that the men had tried to rape her and that she had shot them to protect herself. The evidence told a different story. She carried a loaded weapon to every encounter. She systematically robbed the victims after killing them. Richard Mallory, the first victim, was shot multiple times, including in the back. The pattern of theft, disposal, and pawned goods suggested planning, not panic. For nearly a year, decomposing bodies were discovered by hikers and motorists traveling through Central Florida. The investigation was initially fragmented because the victims were found in different county jurisdictions. Forensic examiners recovered .22 caliber bullets from the bodies and began to identify a pattern linking the victims. Wuornos had been involved in minor traffic accidents while driving stolen vehicles. But she had been released under false names before investigators connected the cars to the murders. The breakthrough came when police tracked pawn shop receipts for items stolen from the victims. Wuornos had left a bloody thumbprint on one of the pawn tickets. Multiple task forces coordinated the investigation, led by detectives from the Volusia County Sheriff's Office. On January 9, 1991, Aileen Wuornos was arrested at a biker bar called The Last Resort in Port Orange, Florida. She was charged with multiple counts of first-degree murder, armed robbery, and auto theft. Prosecutors decided to try Wuornos first for the murder of Richard Mallory. The trial began on January 14, 1992, in Volusia County Circuit Court. Prosecutor John Tanner presented the state's case. Public defenders represented Wuornos. She pleaded not guilty and claimed self-defense, arguing that she suffered from battered woman syndrome and that Mallory had violently assaulted her. The prosecution argued that the killing was cold-blooded robbery, pointing to the fact that Mallory had been shot multiple times, including in the back, and that Wuornos had followed a similar pattern with 6 other men. The most devastating witness was Tyria Moore, Wuornos' former girlfriend who testified for the prosecution in exchange for immunity. Moore's testimony revealed admissions Wuornos had made about the killings. The physical evidence, multiple gunshot wounds, theft of property, and the pattern across victims contradicted the claim of self-defense. On January 27, 1992, the jury convicted Aileen Wuornos of first-degree murder. She erupted in the courtroom, screaming at the jurors and proclaiming her innocence. Wuornos was sentenced to death by lethal injection on January 31, 1992. She later pleaded guilty or no contest to the other 6 murders and received additional death sentences. She filed mandatory appeals for years, but in 2001, she fired her lawyers and demanded that the state execute her. While awaiting execution, she exhibited bizarre delusions, claiming that prison guards were using sonic technology to control her mind. Psychiatrists evaluated her and deemed her legally competent to be executed despite her mental disturbances. 10 years passed between her conviction and her death. After Mallory's murder, it was discovered that he had spent a decade in prison for violent sexual assault. Wuornos had not known about his criminal record when she shot him, but the revelation lent chilling credence to her claim that he had tried to rape her. Questions were also raised about whether Wuornos had been exploited by her adoptive mother, Arlene Prahl, and her own attorney, who allegedly pushed her into plea deals to secure lucrative movie rights. The state of Florida executed Aileen Wuornos by lethal injection on October 9, 2002, at Florida State Prison. She was 46 years old. Her case became the subject of the 2003 film Monster, for which Charlize Theron won an Academy Award, and 2 documentaries by filmmaker Nick Broomfield. The case also highlighted significant gaps in inter-county police communication and led to better coordination among task forces investigating serial crimes. Wuornos is widely, though inaccurately, cited as America's first female serial killer. She was definitively the first woman to operate with the predatory, stranger-targeting violence typically associated with male serial killers. 7 men are dead. Richard Mallory's hidden history suggests the first killing may have been self-defense. The pattern of subsequent murders suggests a transformation from victim to predator. The truth likely lies somewhere between Wuornos' claims of survival and the prosecution's portrayal of a remorseless killer. What remains certain is that 7 families lost sons, fathers, and brothers to violence along a Florida highway, and the woman who killed them spent her final years demanding her own death. Case number 3, Thomas J. Grasso. On March 20, 1995, in the execution chamber at Oklahoma State Penitentiary, Thomas J. Grasso was strapped to a gurney and prepared to receive a lethal injection. Prison officials had served him his final meal hours earlier. Grasso had requested a complex menu that included a can of SpaghettiOs. The prison kitchen did not have SpaghettiOs and substituted generic canned spaghetti instead. When reporters asked Grasso if he had any final words, he used his dying breath to lodge a complaint. "I did not get my SpaghettiOs. I got spaghetti," he said. "I want the press to know this." Moments later, he was dead. He was 32 years old. He had strangled 2 elderly women for a combined total of less than $200. Thomas Joseph Grasso was born on November 23, 1962, in West Babylon, New York, into a working-class family on Long Island. His mother had originally planned to name him Joseph, but a psychic convinced her that the name was cursed after Grasso's older brother, also named Joseph, was killed by a car. He was a high school dropout, a drifter, and a petty thief. He was married to a woman named Lana Grasso. He had a long criminal record across Florida and New York for burglary, assault, and larceny. Those who evaluated him described him as narcissistic and sociopathic, and witnesses noted his manipulative behavior. By 1990, Grasso was unemployed and desperate. Grasso targeted the most vulnerable victims imaginable. Hilda Johnson was 87 years old, a retiree living alone in a modest home in Tulsa, Oklahoma. She was a best friend of Grasso's wife's grandmother, an acquaintance of convenience. Leslie Holtz was 81 years old, a retiree living alone in a modest home on Staten Island, New York. Both women were frail, trusting, and isolated. Grasso knew they lived alone on fixed incomes and had no one to protect them. The murders were separated by 7 months and occurred in 2 different states. On December 24, 1990, Christmas Eve, Grasso broke into Hilda Johnson's home in Tulsa. He strangled her with her own Christmas tree lights. He searched the house and stole exactly $12 in cash and a small television. He locked the door behind him and left her body to decompose. On July 4, 1991, Independence Day, Grasso broke into Leslie Holtz's home on Staten Island. He strangled her with an electrical cord. He searched the house and stole her Social Security check. He locked the door behind him and left her body to decompose. In both cases, welfare checks by neighbors and family members led to the grim discoveries days or weeks later. The motive was petty robbery. Grasso had targeted women he knew were elderly, alone, and had small amounts of accessible cash. The total amount stolen from both victims combined was less than $200. Detectives with the New York Police Department initially arrested Grasso in July 1991 for the murder of Leslie Holtz. They tracked pawned items and followed witness statements that linked Grasso to the neighborhood where Holtz lived. Grasso was charged with second-degree murder in New York. He later confessed to the unsolved Oklahoma murder of Hilda Johnson and was charged with first-degree murder. He pleaded guilty to both killings. The legal proceedings revealed Grasso's calculated manipulation of the criminal justice system. He was sentenced to 20 years to life in a New York prison for the murder of Leslie Holtz. New York did not have the death penalty at the time. Grasso did not want to spend the rest of his life in prison. He wanted the death penalty. Because New York could not execute him, he confessed to the unsolved Oklahoma murder and demanded that he be extradited to Oklahoma, a state that did have capital punishment. He pleaded guilty to the murder of Hilda Johnson in Oklahoma and was sentenced to death. A massive political battle erupted between the 2 states. New York Governor Mario Cuomo, a staunch opponent of the death penalty, refused to release Grasso to Oklahoma and ordered that Grasso serve his 20-year New York sentence first. When George Pataki took office as the new governor of New York, he immediately signed the extradition papers, fulfilling Grasso's wish to be sent to Oklahoma for execution. Grasso waived all appeals. The execution took place on March 20, 1995, at Oklahoma State Penitentiary. Grasso died by lethal injection. He was 32 years old. His case sparked a major federal review of interstate compacts and raised complex legal questions about the extradition of condemned prisoners across state lines. Grasso had murdered 2 vulnerable elderly women for pocket change in their own homes on holidays, meant for celebration. He manipulated the legal systems of 2 states to secure his own execution, rather than serve a life sentence, and he spent his final moments complaining to the media about the wrong brand of canned pasta. Hilda Johnson and Leslie Holtz, strangled in their homes on Christmas Eve and Independence Day, became footnotes to the absurdity of their killer's dying words. Case Server 4, Jimmy Glass. On December 25, 1982, family members arrived at the home of Newton and Aileen Neely Brown in Dixie Inn, Louisiana, expecting to share Christmas dinner. Instead, they found the couple's bodies. Newton, 55, and Aileen, 51, had been bound, gagged, and shot to death in their own living room. The Browns were well-loved members of their rural Webster Parish community. They had been murdered by 2 fugitives who had escaped from the local jail and needed clothes, money, and a car. One of those fugitives was a 20-year-old habitual offender named Jimmy Glass. 15 years later, Glass would make headlines again when he filed a petition with the United States Supreme Court, arguing that his method of execution, the electric chair, violated his constitutional rights. The court denied his petition. On June 12, 1987, Glass was strapped into the chair he had fought to declare unconstitutional, and he was electrocuted. His final words to the witnesses were a grinning joke: "I'd rather be fishing." Jimmy L. Glass was born in 1962 in Louisiana. He was a high school dropout and had been unemployed for most of his young life. By the time he was 20 years old, he was already cycling through the criminal justice system with a history of burglary and assault. In December 1982, he was incarcerated in the Webster Parish Jail on non-capital charges. He had not yet been convicted of murder. He shared a cell with another inmate named Jimmy Wingo. Newton Brown and Aileen Neely Brown were celebrating Christmas morning in their home in Dixie Inn, a quiet rural area in Webster Parish. Newton was 55 years old. Aileen was 51. They were local business owners, respected in their community, and beloved by their family. They were preparing for relatives to arrive for Christmas dinner. They had no connection to Jimmy Glass and Jimmy Wingo. The murders were the culmination of a desperate jailbreak. Glass and Wingo escaped from the Webster Parish Jail, where they had been held on burglary and assault charges. As fugitives, they were desperate for clothes, money, and a vehicle. On the morning of December 25, 1982, they broke into the Browns' home. Newton and Aileen were bound and gagged. The fugitives searched the house for valuables. Then, to eliminate the only witnesses who could identify them, Glass and Wingo shot both Newton and Aileen to death. They stole the couple's car and fled. Family members arriving for Christmas dinner discovered the bodies and immediately called the police. A massive statewide manhunt was launched. Authorities realized that the escaped inmates were armed, dangerous, and willing to kill. The stolen vehicle was tracked, and forensic evidence recovered from the Browns' home linked the murders to the fugitives. Approximately 2 weeks later, on January 6, 1983, both Glass and Wingo were apprehended and arrested. Glass was charged with 2 counts of first-degree murder, prison escape, and armed robbery. He pleaded not guilty and went to trial in Webster Parish Court. His defense strategy was to shift blame entirely onto his accomplice. Glass claimed that Wingo had held a shotgun to his head and forced him to pull the trigger on Newton and Aileen Brown. He argued that he had been coerced and had no choice. The prosecution presented forensic evidence that showed Glass had acted independently and willingly. The jury rejected his claim of coercion. The physical evidence and the circumstances of the crime made clear that both men had participated in the executions. Glass was convicted of first-degree murder and sentenced to death by electrocution. Glass appealed his conviction and sentence all the way to the United States Supreme Court. In the case Glass vs. Louisiana, decided in 1985, Glass argued that electrocution violated the Eighth Amendment's prohibition against cruel and unusual punishment. He claimed that death by electric chair was unconstitutionally painful. The irony was not lost on observers. Glass had shot an innocent elderly couple on Christmas morning while they were bound and helpless, offering them no opportunity to appeal for mercy. Now he was utilizing every available legal resource to argue that his own death would be too painful. The Supreme Court denied his petition for certiorari, allowing the execution to proceed. Glass vs. Louisiana became a major case, cited in later legal arguments about the constitutionality of the electric chair, a method that most states eventually phased out. Approximately 5 years passed between Glass's conviction and his execution. Jimmy Glass died by electrocution on June 12, 1987, at the Louisiana State Penitentiary in Angola, Louisiana. He was 25 years old. In his final moments, secured in the chair he had fought to have declared unconstitutional, Glass grinned at the witnesses gathered to watch him die. When asked for his final words, he delivered a flippant joke. "I'd rather be fishing." Newton and Aileen Brown had been preparing Christmas dinner when they were murdered. Their family arrived to celebrate a holiday and found a massacre instead. Glass showed no remorse in his final statement. He treated his execution as an inconvenience, a disruption of leisure time he would have preferred to spend with a fishing rod. Glass versus Louisiana remains a significant case in death penalty jurisprudence, a legal legacy built on the bodies of two people killed on Christmas morning for a car and some cash. Case number 5, John Spenkelink, Florida State Prison, May 25, 1979. The electric chair known as Old Sparky had not been used for an involuntary execution since the death penalty was reinstated. John Arthur Spenkelink, 30 years old, had exhausted all of his appeals. He had fought his execution until the very end, unlike Gary Gilmore, who had volunteered for death 2 years earlier. Spenkelink would become the first person executed involuntarily in the United States since the reinstatement of capital punishment. Just before the electricity coursed through his body, Spenkelink spoke his final words, a statement that would become a rallying cry for death penalty opponents for decades to come. "Capital punishment," he said. "Them without the capital get the punishment." Moments later, he was dead. He could have avoided execution entirely if he had accepted a plea deal. One decision had cost him his life. John Arthur Spenkelink was born on March 29, 1949, in Lamars, Iowa. His father was abusive and later committed suicide. Spenkelink was raised in poverty and dropped out of high school. By his early 20s, he was a drifter with an extensive criminal history that included petty crime, armed robbery, and prison escapes in California. He had spent much of his young life moving in and out of institutions. He was 24 years old in February 1973 when he committed the murder that would lead to his execution. The man Spenkelink killed was Joseph Szymankiewicz, an adult male approximately 45 years old. Szymankiewicz was a traveling companion. Spenkelink had picked him up while hitchhiking, and the two had traveled together for several days. Szymankiewicz had a known violent past and was allegedly highly aggressive. Spenkelink later claimed that Szymankiewicz had sexually assaulted him, stolen his money, and forced him to play Russian roulette. Spenkelink said he feared for his life and that the killing was a preemptive act of self-defense. The prosecution would argue that the evidence told a very different story. In February 1973, Spenkelink and Szymankiewicz rented a motel room in Tallahassee, Florida. While Szymankiewicz was sleeping, Spenkelink shot him in the head. Then he bludgeoned him with a hatchet to ensure that he was dead. A motel maid discovered the heavily battered body the next morning and called the police. Spenkelink was apprehended shortly afterward as he attempted to flee the state. He was charged with first-degree murder. His claim was self-defense. He insisted that Szymankiewicz had abused him and that he had acted to protect himself. The prosecution countered that the victim had been asleep when he was attacked. A man sleeping in bed posed no immediate threat. The shooting, followed by the bludgeoning with a hatchet, suggested something far more deliberate than a desperate act of self-preservation. The state of Florida offered Spenkelink a way to avoid the death penalty. Prosecutors extended a plea deal that would have allowed him to plead guilty to second-degree murder in exchange for a sentence of life in prison, with the possibility of parole. Spenkelink could have accepted the deal and eventually sought release. He refused. He believed strongly in his self-defense claim and was convinced that a jury would exonerate him. He went to trial. The prosecution presented evidence that the victim had been shot in the head while he was sleeping and then bludgeoned with a hatchet. The defense argued that Szymankiewicz's violent history and pattern of abuse justified Spenkelink's actions. The jury did not accept the self-defense argument. They convicted Spenkelink of first-degree murder. He was sentenced to death. Spenkelink's case became a cause for anti-death penalty advocates, and his legal team mounted exhaustive appeals over the next 6 years. Justice Thurgood Marshall of the United States Supreme Court issued stays of execution on multiple occasions, but those stays were later overturned. Spenkelink's execution would mark a turning point. Gary Gilmore had been the first person executed after the reinstatement of the death penalty, but Gilmore had volunteered. He had waived his appeals and demanded to be killed. Spenkelink fought until the end. He did not want to die. Ugly rumors circulated after his execution, claiming that prison guards had beaten him to death while dragging him to the electric chair and that the state had electrocuted a corpse. Years later, the state was forced to exhume Spenkelink's body and conduct an independent autopsy. The autopsy confirmed that he had died from electrocution. The rumors were false. John Spenkelink died in the electric chair on May 25, 1979, at Florida State Prison. He was 30 years old. His final words highlighted the economic and class disparities embedded in the American criminal justice system, and the phrase, "them without the capital get the punishment," became a famous slogan for legal reform advocates. Spenkelink was the first person executed involuntarily after the death penalty was reinstated, a grim historical marker. The plea deal that could have saved his life haunted the case. One decision, his belief in his own innocence, and his refusal to accept a life sentence, sealed his fate. Joseph Szymankiewicz's violent history never reached the jury. Whether the killing was legitimate self-defense or the murder of a sleeping man remains a question the legal system answered definitively, but one that continues to be debated. What is certain is that Spenkelink died in an electric chair for a crime he could have avoided being executed for if he had simply accepted the state's offer. The tragedy of the case is that it did not have to end the way it did. Case number 6, Douglas Allen Feldman. The execution chamber at the Texas State Penitentiary in Huntsville fell silent on July 30th, 2013. Douglas Allen Feldman, 55 years old, lay secured to the gurney, minutes from receiving a lethal injection. Feldman had been convicted of murdering 2 truck drivers in 1998 in a fit of psychotic road rage. When the warden asked if he had any final words, Feldman did not apologize. He did not express remorse. Instead, he delivered a chilling, formal declaration in which he positioned himself as a sovereign authority pronouncing judgment on his victims. "I have hereby declared Robert Stephen Erminger and Nicholas Vales guilty of crimes against me," he said. "I have carried out their executions. As of that time, the state of Texas has been holding me illegally in confinement. I hereby protest my pending execution." Moments later, the injection began. Feldman died believing that he had been the judge and that the men he murdered had deserved to die. Douglas Allen Feldman was born on June 19, 1958, in Texas. He graduated from Southern Methodist University with a degree in business and worked as a financial analyst. He came from a stable, affluent background. There was no apparent reason for what he would later do. Feldman was diagnosed with severe narcissistic and borderline personality traits and exhibited extreme unhinged anger over minor perceived slights. He had a history of minor drug offenses involving LSD and cocaine in his youth, but he had no major violent felony record prior to the murders. He was 40 years old in August 1998 when his rage erupted into homicidal violence. The men Feldman executed were Robert Erminger, 36, and Nicholas Vales, 62. Both were commercial truck drivers. Both were strangers to Feldman. Erminger was driving his 18-wheeler on a highway near Dallas when his truck allegedly passed too closely to Feldman's motorcycle. Vales was parked at a gas station in his 18-wheeler, taking a break from the road. He had never met Feldman and had no interaction with him before the night he was killed. The two victims had nothing in common except their profession and the fact that they happened to cross paths with a man who believed that driving near him was a capital offense. In August 1998, Feldman was riding his motorcycle on a highway in the Dallas-Plano area late at night. Robert Erminger's 18-wheeler passed him, and Feldman became enraged. He believed that the truck had come too close to his motorcycle, and he interpreted this as a personal trespass. He pulled his motorcycle alongside Erminger's cab and fired multiple shots with a 9mm pistol, killing Erminger. 45 minutes later, still consumed by rage, Feldman saw Nicholas Vales parked at a gas station in an 18-wheeler. Feldman had never met Vales. He rode up to the truck and shot Vales dead purely because he was driving the same type of vehicle that had angered him earlier. Feldman fled both scenes. Passing motorists discovered Erminger's body. Gas station attendants found Vales. 1 week later, Feldman shot another man, Antonio Loya, outside a fast food restaurant following a minor argument. Loya survived and provided police with a license plate number and a description of the shooter. Investigators traced the plate to Feldman's motorcycle and matched his 9mm pistol to the bullets recovered from the truck drivers' bodies. Feldman was arrested outside his home in September 1998. Feldman was charged with capital murder and went to trial in Dallas County. He pleaded not guilty by reason of temporary insanity. His defense attorneys argued that he had suffered a psychotic break and was severely mentally ill at the time of the killings. The prosecution presented him as an entitled, remorseless thrill killer who believed that the world owed him deference. Feldman made the catastrophic decision to testify in his own defense. He horrified the jury by calmly explaining that he had shot the two men because they had trespassed on his personal space on the road. He showed no understanding that his actions were wrong. He believed he had been justified. The jury convicted him of capital murder in 1999. He was sentenced to death by lethal injection. Feldman's attorneys filed appeals, arguing that his trial counsel had been inadequate in presenting evidence of his mental illness. The courts ruled that while Feldman did suffer from mental illness, his anger and narcissism did not meet the legal standard for insanity. He understood the nature of his actions. He simply believed that he was entitled to kill people who annoyed him. Feldman spent 15 years on death row. Throughout that time, he maintained his entitled worldview and showed no remorse for the men he had murdered. Feldman died by lethal injection on July 31st, 2013, at the Texas State Penitentiary in Huntsville, Texas. He was 55 years old. His final words were a terrifyingly formal declaration of his belief that he had acted as a sovereign judge with the authority to execute men who had committed crimes against him. He genuinely believed that Robert Erminger and Nicholas Vales had deserved to die for the offense of existing in his space. He believed that the state of Texas was holding him illegally and that his execution was a wrongful act. Feldman was educated, intelligent, and affluent. He murdered 2 innocent men because of a minor traffic grievance. He killed a second man purely because he drove the same type of vehicle as the first. To his dying breath, he believed that he was the victim. Robert Erminger and Nicholas Vales died because they were truck drivers who had the misfortune of being on the road the night Douglas Feldman decided that his personal space was worth killing for. Case number 7, George Appel. On August 9, 1928, at Sing Sing Prison in Ossining, New York, a 41-year-old man named George Appel was placed in the electric chair known as Old Sparky. Witnesses filled the viewing area. Appel had been convicted of murdering a police officer during a botched robbery in Brooklyn the previous year. The execution was imminent. In seconds, alternating current would surge through his body and kill him in one of the most agonizing ways the state could devise. Appel looked at the reporters gathered to document his death and smirked. "Well, gentlemen," he said, "you're about to see a baked Appel." Moments later, the switch was thrown. The profound cognitive dissonance of the human brain when facing absolute terror had caused Appel's mind to default to a pun. His final act on earth was gallows humor in its most literal form. George Appel operated in New York City's criminal underworld during the 1920s. He was known to law enforcement as an enforcer and an armed robber, a dangerous man who made his living through violence. He had no legitimate employment and had spent years moving through the city's illicit networks. By December 1927, Appel was 41 years old and entrenched in a life of crime with no apparent exit. The man Appel killed was Police Lieutenant Charles J. Kemmer of the New York Police Department. Kemmer was a uniformed officer who responded to a robbery in progress at a Brooklyn eatery in December 1927. Appel and an accomplice, a 24-year-old man named Edward Byrne, were in the middle of a holdup when police arrived. Appel shot Lieutenant Kemmer. Kemmer was mortally wounded, but despite being shot and dying, he managed to scribble down the license plate number of the escape vehicle Appel was using. That dying act would lead directly to Appel's arrest. The note Kemmer left behind allowed investigators to track down Appel and Byrne within days. The trial of a cop killer in 1920s New York was a high-profile, aggressive affair. Prosecutors sought the death penalty, and the evidence against Appel included the license plate number that Lieutenant Kemmer had written with his last moments of consciousness. Appel maintained his innocence throughout the proceedings. "I am innocent of the killing of that cop," he told the court. "I committed other crimes, and I lay that to evil companions. But I didn't kill the cop. I wouldn't kill one." The jury did not believe him. He was convicted of first-degree murder. His accomplice, Edward Byrne, admitted his guilt during the trial and was sentenced to life in prison. There were whispers in the courtroom that the evidence against Appel was flimsy, but no new trial was ordered. The conviction stood. Appel was sentenced to death by electrocution. George Appel died in the electric chair on August 9, 1928, at Sing Sing Prison in Ossining, New York. He was 41 years old. In the final moments before the hood was placed over his head and the current was activated, Appel's brain confronted the reality of imminent, excruciating death. Facing that terror, his mind defaulted to humor as a coping mechanism. The pun he delivered, "a baked Appel," became one of the most famous gallows humor moments in the history of American executions. Police Lieutenant Charles J. Kemmer's final act was an act of heroism. Dying from a gunshot wound, he ensured that his own murder would not go unsolved. He scribbled down the license plate that brought his killer to justice. Kemmer's sacrifice allowed the legal system to hold Appel accountable. Appel's final act was a joke about being cooked. The case stands as a strange testament to the human mind's response to facing death. Even in absolute terror, the brain searches for a way to assert control, even if that control is nothing more than a final, defiant pun. Case number 8, Robert Charles Towery. On March 8, 2012, witnesses gathered in the execution chamber at the Arizona State Prison Complex in Florence, Arizona, to watch the state carry out the execution of Robert Charles Towery. Towery had been convicted of torturing and murdering a 68-year-old retired businessman named Mark Jones in 1991. Jones had been a mentor to Towery, had lent him money, and had even bought him a car in an effort to help him escape poverty and addiction. Towery repaid that kindness by breaking into Jones's home, injecting battery acid into his veins, and strangling him to death. When the warden asked Towery if he had any final words, Towery looked at his family and said, "I love my family. Potato, potato, potato." The witnesses were confused. The words sounded like a bizarre, nonsensical outburst. Only later was it revealed that potato, potato, potato was a coded message. The phrase mimicked the idle rumble of a Harley-Davidson motorcycle engine, a sound that Towery and his nephew had loved. It was Towery's way of telling his family that everything was okay. The revelation made the moment heartbreaking rather than absurd. Robert Charles Towery was born in 1964. By the time he was 27 years old, he was in the grip of a crippling methamphetamine addiction that had driven him into severe destitution. He had a criminal record that included multiple theft and burglary charges, all of them fueled by his desperate need for drug money. He had no history of violent crime before the murder of Mark Jones. The addiction had consumed his life and destroyed any chance he had of stability. Mark Jones was 68 years old, a retired businessman, and a local philanthropist. He knew Robert Towery personally. In fact, Jones had gone out of his way to help Towery. He had mentored him, lent him money to help him get back on his feet, and bought him a car so that Towery could find work and escape the cycle of addiction and poverty. Jones was elderly, trusting, and lived alone. He was vulnerable in the most literal sense, but he was also generous. He believed that Towery could be saved. That belief cost him his life. In September 1991, in Scottsdale, Arizona, Robert Towery and an accomplice decided to rob Mark Jones. They needed money for drugs. They knew that Jones had money, and they knew that he lived alone. They broke into his home. When Jones woke up and discovered them, Towery and his accomplice bound him with zip ties. Jones was helpless and terrified. What happened next was not a quick robbery. It was torture. Towery found a syringe and violently injected battery acid into Jones's veins in an attempt to kill him. The method failed. When the battery acid did not kill Jones, Towery strangled him to death. The man who had spent his own money trying to save Towery's life died begging for mercy. Towery's accomplice later turned on him and testified for the prosecution in exchange for a life sentence. The accomplice avoided the death penalty. Towery did not. The trial took place in an Arizona courtroom. Towery was charged with first-degree murder. The prosecution presented the accomplice's testimony, which described the torture in horrific detail. Forensic evidence confirmed the presence of battery acid in Jones's bloodstream and the ligature marks from strangulation. The evidence was overwhelming. The jury convicted Towery of first-degree murder, and he was sentenced to death. The state of Arizona executed Robert Charles Towery by lethal injection on March 8, 2012, at the Arizona State Prison Complex in Florence, Arizona. He was 47 years old. His final words, "I love my family. Potato, potato, potato," seemed nonsensical to the witnesses who heard them. The revelation that the phrase was a pre-arranged code, mimicking a Harley-Davidson engine, a final message of love and reassurance to his family, added a layer of sadness to the moment. Towery used his final breath to comfort the people he loved. Mark Jones received no such comfort. He was tortured in his own home by a man he had tried to save. He was injected with battery acid and then strangled to death. Jones's generosity, his willingness to spend his own money to help a struggling addict, was repaid with unimaginable cruelty. Towery's family received a coded message that everything was okay. Jones's family received only the memory of a philanthropist murdered for drug money by the man he had tried to help. Case number 9. James French. On August 10, 1966, at the Oklahoma State Penitentiary, a 30-year-old man named James Donald French was restrained in the electric chair and prepared to die. French had committed 2 murders. The first was in 1958, when he killed a motorist he had picked up while hitchhiking. The second was in 1961 when he strangled his cellmate, Eddie Shelton, to death inside the prison. French had a clear motive for both killings. He wanted to die, but he was too afraid to kill himself. He had murdered the motorist, hoping to receive the death penalty. When that failed and he was sentenced to life in prison instead, he murdered Shelton to force the state to execute him. His plan worked. As the execution was about to proceed, French looked at the press corps gathered to witness his death and shouted, "How's this for your headline? French fries." Moments later, the switch was thrown and French became the last person executed in the United States before the Supreme Court imposed a nationwide moratorium on the death penalty. It would be more than a decade before another execution took place in America. James Donald French was born in 1936. By the time he was in his early 20s, he was deeply depressed and suicidal. He wanted to die, but he suffered from an intense cowardice when it came to harming himself. He could not bring himself to commit suicide. He decided that the only way he could achieve his own death was to force the state to kill him. To do that, he would have to commit murder. The first victim was a motorist in West Virginia, an adult male whose name has largely been lost to history. French encountered him in 1958, likely while hitchhiking. The man had never met French before. French strangled him. The murder was deliberate and premeditated, committed with the explicit goal of receiving the death penalty. French was arrested, convicted, and sentenced. But the sentence was not what he wanted. Instead of death, he received life in prison. He was sent to the Oklahoma State Penitentiary, furious that he was still alive. In 1961, 3 years into his life sentence, French decided to try again. His cellmate was a man named Eddie Shelton, an adult inmate who had no prior conflict with French and no reason to expect that he was in danger. Shelton had been a stranger before they were incarcerated together. French strangled Shelton to death inside their cell. The motive was clear. French wanted to force the state of Oklahoma to give him the death penalty. Shelton was an innocent man, murdered purely as a means to French's end. French's logic was convoluted and monstrous, but it worked. He was charged with murder, and this time, he got what he wanted. French pleaded guilty to the murder of Eddie Shelton. In court, he practically begged the judge and jury to sentence him to death. He made no attempt to defend himself or to argue for leniency. He wanted to die, and he needed the state to do it for him. The court obliged. French was sentenced to death by electrocution. He filed no appeals. He welcomed the execution and fought against any delays. Approximately 5 years passed between his conviction and his execution. James Donald French died by electrocution on August 10, 1966, at the Oklahoma State Penitentiary. He was 30 years old. Before the hood was placed over his head, French looked at the journalists who had gathered to witness and document his death. He shouted a final message to them. "How's this for your headline? French fries." The pun was delivered with defiance, a final assertion of control over his own narrative. French's execution marked a turning point in American history. He was the last person executed in the United States before the Supreme Court's decision in Feldman versus Georgia imposed a nationwide moratorium on capital punishment. No executions would take place for the next 10 years until Gary Gilmore was executed in 1977. The convoluted logic of French's crimes is difficult to comprehend. He was too afraid to kill himself, so he killed 2 innocent people to force the state to kill him. The first murder did not achieve his goal, so he murdered again. Eddie Shelton was an innocent cellmate who died purely because French wanted to exploit the legal system to achieve his own death. The motorist in West Virginia, whose name has been largely forgotten, was murdered for the same reason. French got what he wanted. He forced the state to execute him. His final words were a pun. 2 men died so that James French could overcome his fear of suicide. He used his dying breath to deliver a joke to reporters. Eddie Shelton and the West Virginia motorist had no opportunity for final words. They were killed without warning, victims of a man who valued his own death more than their lives. French's execution became a historical marker, the endpoint of one era of capital punishment, and the beginning of a decade-long pause. The absurdity of his final words has overshadowed the tragedy of the innocent people he murdered to achieve his goal. Case number 10, G.W. Green. On November 12, 1991, in the early hours of the morning, a 54-year-old man named George W. Green was bound to a gurney in the execution chamber at the Texas State Penitentiary in Huntsville. Green had been convicted of capital murder for the 1976 killing of John Denson, a 43-year-old Montgomery County juvenile probation officer and reserve deputy sheriff. Denson had been shot 3 times in the chest and had begged for his life. Green had shown him no mercy. 15 years later, Green was minutes away from receiving a lethal injection. The warden asked him if he had any final words. Green looked directly at the warden and barked a command as if he were ordering soldiers into combat. "Lock and load," he said. "Let's do it, man." At 12:13 a.m., the injection began. 4 minutes later, Green was pronounced dead. While most death row inmates use their final moments to apologize, pray, or express fear, Green had treated his own execution like a military operation. The callousness he had shown John Denson in 1976 remained with him until his final breath. George W. Green was a repeat violent offender with an extensive history of armed robbery. He had spent much of his life cycling through the criminal justice system. By the time he was in his late 30s, he had committed crimes across Texas and had established a pattern of escalating violence. He had no empathy and no apparent capacity for remorse. The man Green killed was John Denson, 43 years old, a public servant who dedicated his life to helping troubled youth. Denson worked as a Montgomery County juvenile probation officer and also served as a reserve deputy sheriff. He was a man committed to public service, to guiding young people away from the kind of life that George W. Green had lived. In 1976, Denson's path intersected with Green's during a burglary. Denson interrupted the crime or responded to it. Green shot him 3 times in the chest. Denson begged for mercy. Green ignored his pleas and executed him. Green was also convicted of murdering 2 other people, Jeffrey Davis and Sandra Bailey. The pattern was clear. Green was willing to kill to eliminate witnesses and to secure whatever he wanted in the moment. The trial took place in a Texas courtroom. Green was charged with capital murder for the death of John Denson. The prosecution presented physical evidence of the shooting and witness testimony describing Denson's pleas for his life. Green had shown extreme sociopathy and a complete lack of remorse throughout the legal proceedings. His behavior alienated the jury. He was convicted of capital murder and sentenced to death by lethal injection. Green was the second man executed for Denson's murder. An accomplice had been executed earlier. 15 years passed between the murder in 1976 and the execution in 1991. On the night of November 11, 1991, the United States Supreme Court considered a final appeal and voted 7-2 against granting a stay of execution. Governor Ann Richards of Texas had the authority to halt the execution, but chose not to intervene. Shortly after midnight, on November 12th, Green was brought into the execution chamber and secured to the gurney. The warden asked if he had any final words. Green delivered his response in the form of a military command. "Lock and load. Let's do it, man." The injection was administered at 12:13 a.m. Green was pronounced dead at 12:17 a.m. After the execution, Green's brother, Bobby, turned to the prison officials and said, "I hope y'all are happy." George W. Green died by lethal injection on November 12, 1991, at the Texas State Penitentiary in Huntsville, Texas. He was 54 years old. John Denson was a probation officer who spent his career trying to help young people avoid lives of crime and violence. He was shot 3 times in the chest during a burglary and begged for his life. Green showed him no mercy. 15 years later, Green faced his own death with no apology, no remorse, and no acknowledgement of the lives he had taken. He treated the moment of his execution like a combat operation, barking orders at the warden as if he were preparing for battle. Denson's pleas for mercy were ignored. Green's final words were a command. The callousness that defined his crimes defined his death. John Denson dedicated his life to helping others. George W. Green dedicated his final words to maintaining the cold, militaristic posture that had characterized his existence. Denson died begging. Green died barking orders. The contrast could not be more stark.